And all right,
Back, what's your last name?
Handleman.
Handleman?
sorry about my chicken scratch.
I know that type of thing well.
Yep, we're all set.
Morning. Today is Tuesday, July 14th, 2026. We're the District 5 Environmental Commission. We need to conduct a hearing on application 5W0863-4 filed by the applicant, the city of Barre. The applicant is seeking authorization for a project generally described as the redevelopment of the former O'Reilly Auto Parts Warehouse on Morrison Road into a site for the Public Works Garage for the City of Barre Public Works Department. This would include proposed internal building renovations, reconfiguration of the project site to allow at-grade access to the building for the DPW vehicles, and to add external storage facilities, including pipe materials, salt, sand, aggregate storage, and a fuel depot. Project is located at 277 Morrison Road in Barre Town. I'm Donald Marsh. I'm the chair of the District 5 Commission, and I'm joined with fellow Commissioner Gary Nolan. In accordance with Vermont's open meeting law, I confirm that we have taken the following steps. We're providing public access to the meeting by online video conference, with additional access offered through telephone. We're using Microsoft Teams platform for this hybrid meeting. All members of the commission have had the ability to communicate during this meeting, and the public has access to listen and, if desired, to participate in the meeting by attending in person, downloading Microsoft Teams application, or by calling in the toll-free number which is provided in the hearing notice. In addition, we provided public notice of instructions for accessing the meeting. We've previously given notice to the public of the necessary information for accessing the meeting, including how to access the meeting using the phone and Microsoft Meetings. This document, including those instructions, have also been provided in meetings notice on the Act 250 database online. This meeting is subject to Vermont open meeting laws. By participating, you are consenting to being audio and visually recorded, and for that recording to be published in the board's YouTube video channel. Please be aware that the microphone that is used to record the hearing is extremely sensitive and will pick up any recorded whispers or side conversation or anything that is recorded will be published as part of the record. Any written information or exhibits provided to the commission or Act 250 staff regarding are regarded as official state business and are considered public records and will become part of the permanent record to be published on the board's online database. If you'd like to speak during the hearing, please raise your hand, wait to be recognized by the chair, and we'll have a chance to present, you'll have a chance to present evidence and respond to any information presented. There's no need to interrupt or talk over other individuals. When you speak, please state your name for the record so that the recording will have it. So far, nobody's online remotely. Okay. So in terms of attendance, Barre City is represented by Brian Baker, David Ruff, Esquire attorney, and Zach Helderman, also an attorney. Lane Carnes, and Brian Baker, who's both the city engineer and DPW director. And Denise LaValle is a nearby neighbor, across the road neighbor. Okay. Denise, you provided an email address. Gary and I have reviewed all the materials submitted by the applicant and with an eye of toward identifying any conflicts of interest that we might have. We are not aware of any conflicts of interest that need to be disclosed at this time. Note that outside of today's proceedings, any communications, whether by letter, email, telephone, or in person, must flow through Nate, Barre, and not through any other party or commission members. We are charged with the purpose of this hearing is we're charged with collecting evidence as to whether this project meets the requirements of Act 250, and based upon that evidence, we'll decide whether a permit is to be issued. Ryan, would you like to give a brief summary
Of the project?
summary of the project? We'll get into the details later.
Yes, happy to. As you previously stated, the project is to convert the existing permitted warehouse at 277 Morrison Road into the DPW facility for the town of Barre. It involves minimal interior renovations, reconfiguration of the existing overhead access doors, some reconfiguration of office and bathroom space inside the building, and some structural renovations inside the building to remove columns so that DPW trucks can circulate through the building. Proposed work on the outside of the site includes regrading of existing parking areas in front of the building to create at-grade overhead door entrances where there are currently elevated loading docks, and then development on the west side of the site to create outdoor storage areas for the DPW use. So including a building for exterior unheated storage building for salt and sand storage, pipe storage for water and sewer piping and materials, a storage building that generally for DPW equipment and materials, as well as some storage bunkers for inert materials such as crushed stone, reclaimed asphalt, items like that. We're proposing a new access onto Upper Prospect Street from the material storage area, as well as renovating the existing stormwater treatment pond to provide compliant stormwater treatment for the entire site, current state stormwater regulations.
Thank you. And if there's no one else other than, we have nobody online, other than Miss LaValle, I assume you're requesting party status? On which criteria?
They were listed in the response that I sent. For multiple criteria.
On the addendum.
Starting on page 9.
Well, I have it as a separate document.
Right. And then page 9 of the hearing script, there's also an overview.
Oh, okay.
Thing.
Other use her list because it identifies the criteria. So
So the commission could also break if you want to discuss all the criterion.
I just want to confirm with her that 1G wetlands, 2 and 3 water supply and the impact on water supplies. You had a question here, you noted a spring that's spring fed source 500 feet away. Where is that and who does it serve?
It serves the Bonds property, their home. And There's also the property between the Bonds home and the road, which is the old barn, which is now Tetros Appliances. They have a well. The Bonds,
Sure hasn't.
they have, I believe they have a drilled well. I don't know for sure because it wasn't on the map from A&R. But the Bonds has a spring-fed water supply. And I know this because when I did my perk testing for that level site
Yeah.
up above,
Field.
that we had to alter the test site 25 feet to the north because it was initially within 500 feet of that water supply.
So it's somewhere in the field or the woods below their house.
It's right behind the barn.
Behind the-
They have a pond,
Yeah.
but it's also a part of that whole spring-fed system.
You've noted criteria for erosion control. I know that there's hydric soils. And criteria 5, you noted in terms of new driveway off Upper Prospect. I think we see that. Okay, and you're not noticing how many about odor and noise equipment? And then 8A in terms of scenic tax.
Scenic would be 8A is for wildlife habitat, I think.
Oh, so
What's
scenic is
8?
just 8.
Just 8.
Okay. Note that. Don't think I understand your question about 9A. Could you explain that? Impact on growth?
Part of the town plan. They said they
Talking
would,
about perk test and a septic system, I'm not sure how that has anything to do with impact on growth. It says the proposed construction be unsuitable for a new home to be, I don't think I understand what you're getting at there.
so the town plan, when it talked about growth of residential dwellings,
Yes.
if this moves forward and is permitted, then it's going to affect the local properties where people want to build a new residence. They're not going to be able to stay within the low density residential and expect that it's protected.
And the prime ag. Versus I understand what you're saying there. A little confused as to how operating the municipal garage impact residential development. Did you explain that on 9H and L?
It's similar to what I just said, because already one of the small residential structures there has been put on the market. The people are going to vacate. They're not going to be able to maintain this low-density residential, if this municipal garage is permitted, even though they considered it an alternate use approved, it has an impact on people who want to live in a low-density residential area. And that's what the zoning is, and agriculture. And I submitted as well as have maps that show the majority of those properties are agriculturally zoned. And it is part of the plan that they wouldn't have a negative impact on wildlife, on the forestry, or low-density residential neighbors.
And to understand a little bit better, the walking paths are throughout your property?
The
In
portion,
terms of that, your clients use?
portion that's already finished is on the higher level section to the south side of the driveway.
Okay, south of the drive.
Yes,
No trails at the moment on the north side.
no, yeah. They exist, but they're not finished.
Okay. Yes, sorry.
I want to address this, raise this point now, but it was raised in our opposition to our party status petition, if you're familiar with that. And it has to do with Miss Valley's ability to be here on behalf of herself versus like the Nature Center Corporation, and the inability for her to represent the Nature Center in this proceeding, because she has not demonstrated that she's the agent or has any ability to represent a corporation. That is limited usually to attorneys. So she has to either pick, she's here by herself, not on behalf of the company that runs the nature trails and the activity on her property. And we raised that in our party opposition to our party status petition. I just wanted to make sure that the commission was aware of that legal argument and that it make sure to address it with its hearing order.
Thank you. Do you have any response to that?
Denise LaValle, I didn't receive any party opposition. I don't know what he's talking about. I'm the president and owner of the company. It's registered with the state. There shouldn't be any opposition to my being legally able to represent them. I represent them in any other legal faction, financial or otherwise.
Mr. Marsh, she has not raised Milestone Nature Center in her party status petition. And this opposition was filed with the district commission, like everything else that we filed in response to the hearing recess order on June, I believe it was 26th. And it's part of the record of the proceeding.
I don't think I've seen that
That was in the,
unless I didn't print it.
it was exhibit 36.
Didn't hear that.
It's exhibit 36.
36. I can pull up a copy of it on the screen, or if you want to, and if you want to take a look at it in more detail when we break.
Okay, yeah, we'll look at it in the break.
The fundamental issue is that she is appearing as personally as herself, and she's purporting to represent also the company. So,
I understand that.
Yeah.
I understand the issue. I just hadn't seen your brief,
oh, okay.
but I just didn't print it. We need to.
If the commission would like to break to discuss.
We're going to break. If you could excuse us for a little bit.
I think that would be important because the brief addresses all of the additional criteria under which she's seeking party status. So the commission preliminarily granted her party status under 5A, 8, and 10, correct? But now she's asserting the 8 or so other criteria under which she purports to have party status, and our brief addresses each one in turn. In general, her arguments for party status are not specific or particular to her. She's raising issues on behalf of the general public under which she has no standing. So that's the principle under which we filed our brief, and
Okay.
that goes through each of the criteria under which she seeks party status and addresses her arguments.
If you'll excuse us for a little bit, we'll review that and give you a yell when you go back.
Should be back online.
It's a green.
It's a green.
Green and gold. Yes.
Okay, we are going to grant preliminary party status. Me,
Preliminarily grant party status.
what I thought I said. Preliminarily grant party status to Miss LaValle on criteria 3, 5A, and you already were granted party status earlier on 8 and 10. And for now, we'll let you testify for both you and the corporation. But prior to finalizing the record, if you could please provide us with documentation that you're authorized to speak on behalf of the corporation. Either a vote or resolution or letter or something that the corporation allows you to be their representative. So you can file that with the other information subsequent to the hearing. Other issues that commissions decided to limit some of the criteria that we'll address today. So we intend to address criteria 1A, criteria 1B, waste disposal specifically related to stormwater. G, wetlands. Criteria 3, impact on water supplies. Potential impact. Criteria 5A, transportation. Criteria 8, aesthetics, scenic, natural beauty. Criteria 9B, primary ag soils. And we'd like the applicant to provide information as to the acreage of prime ag soils that expect to be impacted, which would just be the parking lot and the new driveway off Prospect. And criteria 10 to confirm the conformance with both local and regional plans. Any questions or objections to that? Nation? Yes, sir.
We, as the applicant, have already submitted evidence under some of those criteria.
Oh, I'm sorry. Excuse me. We think that the applicant, thank you for reminding me. We think the applicant in the Wolf memo of 26 June has adequately addressed criteria 10. We'll have that on the record.
I think we had prime ag soils addressed under a letter submitted as exhibits. One.
It's 15.
15.
And then additionally, the response to the incomplete letter.
So you've addressed that in the, we're okay on that then? Okay, then we'll eliminate that.
What was that?
That would 9B, prime ag soils. You have a letter from the agency on that one.
We do not have a letter from the agency, so I'm happy to address it now if the commission would prefer. But our evidence that was filed with the application, we had extensive communication with several district coordinators around the history of the Act 50 permitting on the site. And essentially the district commission in previous permits on the site established a project area that was previously reviewed for prime agricultural soil impacts. The proposed project is within that project area, and the commission in previous decisions had ruled all of that area as already impacted by the permitted development of the project.
Specifically, this is the -1 permit, finding of fact number 54.
Thank you. So that all of that correspondence, district coordinators,
He's on the record, so that's
Yeah.
filed on the record.
It's exhibit 15.
okay.
Exhibit lists. And then I think there was also something in the exhibit, sorry.
Somewhere near 20, I think.
26.
6, yes, incomplete letter. Thank you, Dean. Stormwater. We have the final permit,
We do. Yep.
and that's exhibit 34. We have a construction permit. Storm.
34 is the operational stormwater.
Construction permit is 27. That should deal with 1B, or at least the presumption. Get us over the hump on the presumption. Purposes of today's hearing. So
The
there's
correspondence from
there's the-
defendant person.
And the last one is on 1G. Exhibit.
Bannon is written off on that.
Yes, exactly.
Okay, so
Just try to limit what we have to discuss because we've already submitted it.
that's fine.
Agree with that, you haven't had
Agree.
these issues.
Okay, so that removes BG 2.
1B, 9B, 10. 2 is not an issue.
9L wasn't there anyway. Okay,
I think I have 1A, 3, 5A, 8.
say that again.
1A, air, 3, water supply,
Yes,
5A, traffic transportation, and 8, aesthetics.
yes, I agree.
Thank you.
All that. Save details a little in there.
Okay,
Yeah, we'll rest on our
Yeah, that's fine.
hearing memo on 10.
Okay, good, then why don't you start with 1?
So I understand that the issue at hand under 1A is related to blasting primarily. We're not expecting any other significant sources of air pollution, noise that rises to a health concern under this project. So in our response to the Oh, I'm sorry. 1A's headwaters, not air pollution.
Yeah, we're thinking of air in terms of cases, odors and fumes and exhaust. I mean, it is blastings in there also, but you've addressed blasting. We don't have any issues with that at all. Or the lack of need for blasting, which we think was a good settlement. The other issues would be dust or odor, rust. I understand it's really health related as opposed to nuisance.
So we are not expecting significant dust generation from this site. There won't be like large areas of the site that are like open and disturbed earth and being worked. All of the travel way around the site will be paved. So there isn't dust being generated from driving over, say, gravel roadways and things like that. The large majority of the material storage is covered under buildings, so it's protected from degenerated dust as well. The materials that aren't under cover are generally inert material storage, so crushed stone, crushed gravel, and reclaimed asphalt, which again aren't significant sources of dust. In terms of vehicle emissions, the operation of the DPW site is not similar to, say, a construction site where vehicles remain on the site all day, circulating and moving. So the DPW, by its nature, the purpose of it is to maintain the city's investments in its public works, roads, water system, sewer system, those kinds of things. And by the nature of the work, their work locations are out in the city, wherever that work needs to be accomplished. So the typical operation for city crews is to arrive at the site, load what they need for their work task for the day into their vehicles. They typically travel in multiple staff per city vehicle when they leave the site. They go to their work site in the city, they perform their work. They may return to the site once or twice during the day for additionally to get additional materials if needed. However, that's a really inefficient way to work when you're out in the city. So the policy and the way the operations are organized is to minimize return trips to the site. So there's not typically, say, like excavators or loaders working on the site all day. They work when things need to be loaded on a truck, and then otherwise trucks and large equipment is going to be parked inside of the building. So generation of emissions from vehicle circulation isn't it's anticipated to be more impactful than, say, the roadway, where there'll be significantly more vehicles traveling during the day than be operating at the site.
Anticipate spring sweeping of the parking lot to pick up. I assume you have winter sand.
Yeah, so the city's policy is to sweep as they are loading. So if there's a spill or something when they're loading, they will be sweeping as they go. So I don't know, Brian, if you typically sweep in the spring.
We normally do to clean stuff up, but wouldn't necessarily have a whole lot of the sand pile usually is fairly dormant during the summertime. So, spring cleaning would probably be expected.
Yeah, so sweepers would be equipped to water.
Yeah, we have one now that fills up, and we are actually installing a connection at the building so that they can fill up directly right from there. So
I think the fueling pumps will be constructed in accordance with all the applicable air pollution permitting standards for containment of gasoline and the like.
Valerie, do you have any comments on criteria 1?
All I can say is even if trucks are pulling into the building to park there, the exhaust is still there, whether it's in the building and it seeps from the building or whether they're in the parking lot. The excessive amount of traffic and the exhaust is what it is.
Did provide data on slightly larger than what heard in the prior use.
That's a contention because I got information directly from the manager of the O'Reilly's warehouse, and things are contradictory there.
Well, then if you can provide those data to us. Data that.
Sure.
Sure.
I'd just like to point out in the context of comparing impacts between the current use and the proposed use, our contention is that the appropriate comparison is between the permitted use of the current property, the currently permitted use of the property, rather than what may or may not have been happening with the specific warehouse that was existed on the site. So the use of that site has been declining over the years for many years, and is not representative of the impacts that would be allowable under the current permit. So our basis of comparison is the permitted use of the warehouse, rather than what may have been recently occurring on the site.
Is that permitted was typical of the original historic use of it?
Certainly, yeah, back in the early 2000s when the expansion to the current size was permitted.
As you know, we use the trip generation manual from ITE to measure traffic, trip generation for uses like this. And so that's what we're using to measure the permitted use for a warehouse. So land use code 150. And that evidence was submitted as part of exhibit 43.
See that?
There,
Yes.
initial meeting at the planning commission, they stated they would not exceed the type of traffic that had been.
Sorry. Don't think may have occurred in another forum is appropriate here.
Just pointing out the contradiction in what they're saying.
If you can document that, we'll read it. I could be passing another forum. Tier 3.
So my understanding of the primary issue in criterion 3 is not necessarily impact on other water supplies from the use, as there's no increase in water use versus the current wastewater permit for the site, as well as it's connected to the municipal system. So there's no groundwater withdrawal for water use at the site. So my understanding of the primary concern around water supply is the impact of the proposed underground storage tanks. So with our response to the pre-hearing order, we included the application to the underground storage tank permit program with the state. So there is proposed one 5,000 gallon gasoline storage tank and one 10,000 gallon diesel storage tank. The storage tanks, as well as the pumps and dispensers, are equipped with all of the required protection and mitigation against leakage and spillage. So both the tanks are double walled fiberglass construction, which provides secondary containment for the tank itself, as well as a non-corrodable material for the outside of the tank. There is secondary containment proposed at the tank for both the filling the tank as well as the pump to the dispensers, which does include overfill protection at the tank. The piping from the tank to the dispensers is all double wall piping. It will also be installed inside of a pipe duct. And there will be electronic leak monitoring of all sumps and all interstitial spaces in the system. So there'll be a monitoring panel that will be installed inside the building that will include, monitoring of leakage and alarming, as well as level monitoring for the tanks. So that we could fill if they're already full. At the dispensers, the dispensers themselves will have containment sumps. They'll be placed on a concrete pad. Stormwater from the site is routed around the pad as shown on the grading plan. They're provided with vehicle protection bollards for impact, and the pumps are controlled by a fuel management system. So that all of that has been submitted to DEC and reviewed by the underground storage tank program. We submitted some correspondence with Susan Thayer. The permit has not yet been issued, but the reasoning behind that is that the UST permit has a 1-year period in which the project has to be constructed. Due to both this permitting review and an appeal that's working its way through environmental court currently unrelated to Act 250, the city has not requested that the permit been issued. So we submitted an email from Susan Thayer saying she's ready to issue the permit when requested by the city. So that technical review has been complete. In terms of nearby water supply, the nearest private well is at just pull up to
265.
Thank you. 265 Morrison Road. So the house that's adjacent to the project to the south. We did submit the well log from that house showing it is a drilled bedrock well. The city also had correspondence or conversation with the landowner because that particular well, the wellhead is installed underground. So it's a little difficult to know exactly where it is, but we showed it its location on a plan that we submitted based on previous wastewater system and potable water supply permits, as well as discussion with the owner about the location. And then we also submitted the required well isolation distances from fuel oil, gasoline, and other petroleum tanks and piping for both water sources in bedrock and then water sources in unconfined superficial aquifers. So that would include springs. The nearest well at the neighboring property is more than 100 feet away from the tanks. At the minimum required separation distance per the wastewater rules is 25 feet for bedrock wells or 100 feet for unconfined. So the tanks achieve the appropriate separation under DEC regulations from nearby water supplies.
Exhibits 46, 47, and 48.
So in summary, the tanks are provided with robust protection from leakage as well as monitoring to allow any potential leak that may happen to be promptly addressed for it.
And we understand the permit being withheld and submit that when it's written. That she issues it.
I mean, if it's necessary for this review, we're happy to request that the permit be issued and then, request an extension of the construction timeline.
I think the correspondence demonstrated why they're holding off, and I think that makes sense. There's no need to issue it, then have to reissue it. Do you have any questions on period 3? Relative to the tanks?
They only questioned the well at number 265 Morrison Road. They didn't address the one across the road or the spring water.
You're saying that the stuff across the road was the one with the spring.
Across the road is the barn with the water supply.
Okay, I'm sorry. House.
That is the house with the spring and the pond. I don't know the distance according to the map. I
Observed it. I mean, it's a significant distance.
Yeah, if the farmhouse well is 117 feet from the closest tank, with the farmhouse itself being between 120 and 125 feet from that tank. Those wells are clearly hundreds of feet further away from.
Thought the 117 was to the house on the same side of the road as it was.
Yes.
The other side of the road's further.
Even further, yes, by about another, by scale, it looks like by another 100 feet or so further.
Spring is further yet.
Is further, yes, to the, east, yeah.
So if a
Down
septic system,
gradient.
if a septic system can't be within 500 feet, can a fuel system be within 500 feet?
Different rules, yes. Just a different set of criteria for different programs.
Can I ask, do you have any concern about the project's impact on your well?
Only underground. I mean, if it leaks and it contaminates that water source, every one of the wells is going to be impacted, including mine. If it's 120 feet deep, I'm not 120 feet higher than the subject property. So the whole watershed would be affected. I will tell you, when they drilled my well, they found a cavern. The professional who did the drilling said he's never, except once in his lifetime, ever heard of a cavern like that. So something underneath at maybe 80 feet, there was a cavern they had to reinforce with concrete. So I don't know what impact that has on anything that's going on with this situation and what type of vapors or fuel contamination would occur across the watershed.
Does seem that the proposed installation is quote unquote state of the art with monitoring throughout. And you've understand it, you've contained double line pipes in a secondary containment pipe.
Tertiary containment pipe.
Okay.
Yes. Yeah, the double wall pipes already provide secondary containment. I just also note that I would assume that Ms. LaValle's well is adjacent to her house, which is significantly uphill of the project. Generally, groundwater flow follows the contour of the land. So you would expect the groundwater would generally flow from uphill to downhill, which would make it physically impossible for contamination to travel the significant uphill distance from the tank to Ms. LaValle's well specifically.
I agree with that, but I mean, she does have a point that if bedrock aquifer were to be contaminated, then uphill, downhill doesn't really apply. It's more the layout of the fractures.
If it's the same,
I don't think it's a particular issue, but I mean,
Yeah.
she has a point in that respect.
if it's the same aquifer, sure.
It is.
We don't know that. Oh,
I've submitted the aquifer map, so it is. And the 180 feet, I'm only about 80 to 100 feet higher elevation than the property subject. My well is 180 feet deep, so considering,
Understand. I think you put in one of your briefs, you've outlined that pretty well. Five A in terms of transportation.
As you had noted in our response to the pre-hearing order, we did provide additional information on our trip generation calculation based on the ITE trip generation manual. As stated in both the response and our original application, additional traffic compared to the existing permitted use. There is some additional traffic. It is fairly minor. We're predicting an increase of 7 vehicle trip ends during the PM peak hour, which is not expected to have any significant or measurable impact on levels of service at nearby intersections. Relative to the new driveway and traffic safety, as submitted in our application, let me just pull up the numbers so I can quote them accurately. Second here. Site distances from the new driveway are 410 feet to the northeast. is direction along Prospect Street towards Barre City, and 450 feet to the southwest, which is towards the intersection with Morrison Road. Prospect Street speed limit is 40 miles an hour. So per V-Trans B71 standards, there's a 445-foot intersection sight distance. So we are below that sight distance to the northeast, but
I'm sorry, I didn't catch that number.
445 feet sight distance. The sight distance to the north is 410 feet. So while we are below the intersection sight distance, we are above this minimum stopping sight distance. So just to provide some background on that, the minimum stopping sight distance is the distance that's generally accepted as the amount of distance that a car needs to stop before colliding with something when traveling at the design speed, which in this case is the speed limit. So we do exceed that by over 100 feet in terms of actually being able to stop if a truck is pulling out of the driveway and a car is approaching from the Barre City side of Morrison Road, so from the north. The intersection sight distance is designed so that a car exiting the facility has enough distance to see if there's an adequate gap to enter traffic without causing people to have to slow down from the speed they're traveling. So there may be some minor impact to traffic flow when trucks are exiting and if traffic's coming from the north, but we don't expect it to be a safety concern in terms of traffic on the roadway.
I believe you noted that in spite of sort of the peak hours, that most of the staff are gone essentially before or at the very beginning of the peak hour time frame.
Yes, the operational hours for DPW are 7 a.m. to 3:30 p.m.
So 3:30, you're well short of that, and 7 is at the very early part of a peak hour, the AM peak hour.
And most of the traffic during those peak hours, we'd expect to be employees traveling to and from the site. So, you know, in the morning, they have to get there, load the DPW vehicles and then leave. So that the DPW vehicles would be delayed somewhat from when the employees arrive at the site. But again, typically DPW employees travel with multiple employees per vehicle when they leave to go to a work site.
Isabella, do you have any comments on 5A?
Do.
Please.
And I submitted this information that their stopping distance is only relevant to a passenger vehicle. It's not a truck. It's not a truck hauling a trailer with equipment on it. So their vehicles aren't consistently going to stop in that same amount of distance that they specify. And he mentioned just a truck exiting the driveway. He doesn't talk about trucks entering the driveway from coming from the city. So if they're coming over that blind area to be turning into the driveway or coming to the next intersection and turning down Morrison Road, they're still traveling at 40 miles an hour, and stopping distance is not what they specified. That's for passenger vehicle. Yes, it's slightly uphill before you get to that blind spot. That doesn't slow things down when it becomes level.
Brian, to address your vehicles coming up to the site, they come up Prospect or up Morrison, or it depends on.
I would assume probably most of them would come up Prospect. That is the more direct route to our general area.
And they'll enter into that new driveway?
They will
They go to Morrison and come in.
probably go to Morrison.
Some of them it is a two-way driveway, so they have the option, exhibit.
The bigger equipment doesn't the circulation make more sense that the bigger equipment would come in off Morrison?
Yeah.
Exhibit 42 is a traffic flow map that provides the option of trucks going either way.
And the site distances I'm quoting are relative to the safety of the new intersection. So the safety of the new intersection is really defined by whether the traffic that's generated by the project is creating a safety hazard for vehicles already traveling on the road. The standard across Vermont is the V-Trans B71 standard drawing, which includes intersection site distances, which are applied in safety analysis of new driveways across the state. The stopping distance of the DPW trucks isn't particularly relevant to this safety analysis because they're going to be stopping to enter the driveway no matter what, and we wouldn't expect non-DPW traffic. Well, non-DPW traffic is going to be prevented from coming in or out of the new Prospect Street driveway because it will be gated and only accessible to DPW vehicles.
That's also shown on exhibit 42, and
as well as the site plans.
yeah, Brian, just also, it appears from the traffic flow patterns in our studies that only in the very rarest of cases would travel going to the west or in other words, taking a left turn from Morrison onto Prospect Street. That generally correct.
Yeah.
Let's say, 90% of the time, the DPW trucks are not going to be going left or sort of, I guess that's west on Prospect Street.
Yes, I would agree.
So they aren't crossing traffic.
Exactly. In other words, they also are not going in front of Vista Valley's property or driveway. Up to the very,
They're
very.
not gonna do any work in Berlin.
I hope not.
Thank you.
The other issue with the parking outside of the ballpark, parking on both sides of the road extensively when there's events going on. And they're not just events that happen after hours or in the summertime or on weekends.
Those activities, don't they mostly happen in the evening or no?
No. And I can hear all their activities from up on the property, so I know when they're in session or having an event. I've actually walked the property trying to find who was trespassing. It was so loud.
That's seems to me that's a Barre Town
Youth Sports Association.
Barre Town police issue in terms of if the parking is causing problems. Concern and jurisdiction. Correct.
Assume so.
I would.
Yeah, I mean, certainly the city has no control over whether people are attending events at the private sports facility located adjacent are parking on the road. And as they're not, is an enforcement issue, as you had noted. And I would note that that's a traffic safety issue for everyone who travels on Prospect Street and is not certainly limited to DPW vehicles traveling along a public road.
Okay. Okay. Pete?
So with the response to the pre-hearing order, we did submit on the drawings of the proposed buildings. So the aesthetics of the existing building are essentially unchanged from the way it is now. There would be some on the building itself, some consolidation of overhead doors, a relocation of overhead doors, some changes in the egress doors from the building, but on the building itself, those are the extent of the changes. At the commission's request, we submitted a landscaping plan with additional landscape plantings along the Morrison Road and Prospect Street frontage. The location that we can feasibly provide landscaping. So the landscaping is intended to augment the area of existing trees and bushes that's being retained at the northeast corner of the site. So it sort of extends, sorry, northwest corner of the site, extends that area both along the Orson Road and Prospect Street frontage. The amount of landscaping that we can plant is limited by existing utilities. So there's overhead utility, electrical and communications utility along both of those frontage. Typically, Green Mountain Power will trim anything that's within 10 feet of their conductors. So we were trying to maintain a 10-foot offset to the conductors so that the landscaping that is proposed can be maintained at as large a possible size over the lifetime of the project. And then along the Prospect Street frontage, there's also the city's municipal water line, which dead ends in a hydrant along the project frontage. So in order for the city to be able to maintain their water system, we have to maintain access to that hydrant. And also don't have the ability to plant trees over the water line where they may cause damage in the future. In terms of the noise impacts under criterion 8, we had provided a narrative in both during conference response as well as in the response to the complete for the project.
Number 26A.
Yes, thank you. Relative to portions of the site design that are specifically intended to mitigate noise impact from the project. Happy to run through those.
Well, I think you covered it pretty well in your submittal.
Sure. Happy to stand on the submittal as well.
It's
I also don't believe there are any mandatory provisions of the town plan that would apply under the aesthetic criterion 8 aesthetics analysis. Okay.
Could you repeat that, please?
There are no mandatory specific provisions in the town plan that the project would offend under the criterion 8 aesthetics test, so-called Queechy test.
Here, does that include setback requirements? Town plan?
You'll get to, let's deal with that under 10. Post 8. 8, we're dealing with this case noise related aesthetics. We're dealing with 8 that is under aesthetics and as related to noise as opposed to conformance with the town plan. We'll get to that. Do you have anything else on 8? In terms of their aesthetic criteria?
Are you asking that the applicant?
No. Valerie, do you have anything else on, I mean, the landscaping plan was fairly detailed and addressed specifically the rest of the commission.
Repeat that so I know exactly what you're saying.
They've submitted a landscaping plan, which was in response, a request of the commission to address landscaping on the north side, near the new entrance, between new entrance and where some of the new buildings are for storage. So those buildings are somewhat screened from Upper Prospect. Remember the exhibit number, but it's a landscaping plan.
So with the town plan, I have a couple of things that I would think are applicable, although she's saying
We're all set with criteria 8.
8
Sounds like,
on the same issue.
okay, town plan. Okay, we'll jump to,
Saying there's no mandatory specific to this.
let's jump to 10, which is now talking about the town plan and regional plan. Let the applicant address that first.
Mr. Chair, I just wanted to be clear that under some conditions, statements in town plans apply using the Queechy test under criterion 8. And that was my point,
Oh, okay.
was that using the Queechy test and looking to see whether there are any clearly written community standards governing aesthetics of the site under the Queechy test. There's nothing in the town plan that this project offends.
That's what you.
That's what I was getting at. I was not getting a general town plan conformance. I was just finding referencing the Queechy test and the undue adverse effect analysis.
And it's a term offensive to the average.
Average person, and then you go to the clearly written community standards, et cetera, et cetera.
It's hard pressed to come up with a determination that the project is offensive to the average person.
And in fact, we're trying to comply with the plan by reusing an existing building, so.
So now we will jump to 10. You can address that, Brian. Actually,
The applicant has made its case already under 10 in its post-hearing memo, so I think we'll rest on that.
we're okay with that also. We think that that's adequately addressing any issues on that. Mr. Vadi, do you have questions on criteria 10? Which is into conformance with the regional plans. And they've, as you can see, they've had a detailed submittal on these issues.
So I already submitted information about where they were not compliant with items 6, 9, 10, the goals number 3, number 5, and number 7. And then going through the plan again, I see some of the criteria that should be applicable is to maintain and enhance recreational opportunities for Vermont residents and visitors, which is plan number 8 in the plan. That the plan itself is the final document. There is much more value in the process of engaging stakeholders along the way, establishing goals and objectives related to the 12 required elements of the plan, implementing the plan to carry out the recommendations, working towards becoming more flood resilient, as well as monitoring and mitigating fluvial erosion when possible is important. There's still some issues with what they've got already designated as wetlands, but there's still things going on. And I believe there's been some mowing to eliminate foliage that indicates there is more wetlands than what's already been determined. Based on the map that I was given by A&R and photos that I've taken since that show there's swampy areas that aren't identified. And working to ensure that the town's plan and interests are properly interpreted and protected. And I don't believe that they're being, because I was told that the plan doesn't matter. And the plan does.
We agree the town plan matters. I'm not sure if fluvial erosion comes in or flooding comes in on this site.
When they erect those new buildings, they're going and put more concrete in to put in the fuel tanks. They're making runoff. The risk is there. They've already got issues with water runoff. And when they put those non-pervious surfaces on, it's going to cause more runoff, which is going to cause more discharge, which is going to do fluvial erosion right there on their own property. And I've got a photo to show you, and the adjacent properties downhill.
If you can submit that data when you submit it, please.
Do you own any adjacent properties downhill of the site?
Didn't hear the question.
Vista Valley, do you own any properties downhill of the site? Adjacent to the site?
I don't.
Thank you.
I mean, it was getting at, I mean, you need to have a particularized property interest. It could be a particular interest, not property interest that could be affected by the project as it relates to one of the criteria. So it's hard pressed for, I mean, we understand your concerns, but it's hard pressed for us to address that for you personally. And you're uphill of the project and across the road.
So part of the plan is to protect other residents, and those other residents are at risk. So how does the plan apply if it's only to me and my property?
No, I mean, we'll look at the plan and take judicial notice of both plans, the town and regional. Determine how they.
Can I make a comment regarding stormwater discharge and erosion hazard?
Sure.
So because this site had an existing stormwater permit and we were modifying the currently permitted stormwater treatment pond on the site, then in our stormwater design, treated the site as if it had not yet been developed. So all of the existing impervious area on the site, which if we weren't modifying the stormwater treatment, we would otherwise not be required to treat under the state stormwater rules, is being treated in the new stormwater treatment wetland, which provides both water quality treatment in terms of treatment for sediment and nutrients, as well as several different categories of flood mitigation and discharge. So for instance, in the 1 year storm, which is a storm that is expected to happen every year and is one of the contributors, main contributors to fluvial erosion. The pond collects all of the runoff from all of the existing and proposed impervious on the site and provides 12 hours of detention where we release that stormwater over a very long period to avoid the sort of peaks contribution to peaks in stormwater runoff that happen on a regular basis that can cause fluvial erosion. Additionally, our treatment for the 10-year storm, which is I don't have the numbers right in front of me, but typically something like 3 to 4 inches of rain in a 24-hour period. We are reducing the peak stormwater discharge from the site to below what would be considered pre-development conditions before the existing warehouse was built on the site. For that is discharged from the site. So not only is there flood protection from stormwater from the proposed development on the site, we're providing additional mitigation for the existing development on the site that wouldn't typically be required for a site redevelopment, but is required in this case because we're modifying the existing stormwater treatment.
And that includes the new impervious related to the fuel tanks.
Yes, that impervious is collected and routed to the proposed wetland.
As well as the new driveway.
Yes. I should be clear, when I said wetland there, I meant constructed stormwater treatment wetland.
I understand.
Class 2 wetlands.
I understood that, but thank you.
So are they permitted? I mean, is it acceptable to be doing work like this without the Act 250 permit being issued? I thought you couldn't touch property until the resolutions came in from the Land Use Review Board.
I think I know what you're talking, the work that we did on the stormwater pond.
Anything that he's talking
That
about.
was a repair according to the existing stormwater permit. There was some erosion at the inlet. In order to get our annual inspection, we had to repair that section. And that's the work that was done at the stormwater pond.
This is the work that you had mentioned in one of your memos about excavation work on the site. The valley.
With we put some new
Riprap.
riprap in, yes.
And that's a typical maintenance.
Right. Or that was under the existing,
Stone.
yes. Erosion control stone.
So that's my question. They've been doing work, just what he just described, and the stones that were put in, and it was so wet that the truck that delivered them had sunk into the mud. It was on the site when we visited for the pre-conference hearing.
But that's a maintenance issue that is required under their existing stormwater permit. So
They don't have the existing stormwater permit, it's previous owner.
it goes with the land. So if they're complying with that or as routine maintenance, that's what you'd expect. It's important that they maintain the existing infrastructure. even pending a future permit.
They're required to comply with existing permit conditions governing the site and then on redevelopment, any new conditions that are part of the new permits.
No, I don't have. I think everybody's covered everything pretty well, and we get the information from this valley that. And that. I'm good with.
Nate,
what we got
anything
today.
we've missed?
Nothing on my end. I would just double check with Ms. LaValle and make sure that she's provided all the testimony that she. The criteria.
Is there anything else that you have to, on any of the criteria that we might have missed that you want to add now?
I do want to say that in the beginning, because I was under time constraints and I was not familiar with the whole process,
Understand?
I put in my criteria at that time was relevant, what I knew. Then you gave me the opportunity to do the rest of the criteria
Yes.
in a period of time, and was I submitted. Every meeting I have attended, there has been issue brought up about the existing permitting that I went through and opening my new business. So it's not like it was a surprise, and it's not like it's not relevant. It's relevant because it exists, and I worked hard to put this thing together, and what's associated with the business I'm going to be presenting as you had suggested. And I'm looking at validation in what I've already done and what I plan to do.
I don't think we'll have any problem ultimately with including both you and the specs. That's not going to be a problem. See what you submit. It's just a formality to document your ability to represent the business. Is there anything else that you, I mean, you did have a memo on the potential impacts of the project on your clients,
Correct.
which is in the record.
So with what was presented, I'd like to know what legislation requires I must have an attorney to represent me for this, for the business.
We've agreed to waive that. You may object, but
Yeah, I think that that requirement certainly applies at the state court level. Maybe not at the district commission level.
I'm sorry, could you repeat
The
that?
requirement applies at the superior court level,
Okay.
certainly. Likely not, maybe not at the district commission level.
Well, we've talked to council. I think we're comfortable that we'll make a final decision once, we submit a recess memo.
And is there case law that refers to an attorney being required?
There is, but I think we're going to waive that. It's the initial response we got from our attorney.
Thank you.
You want to set a name for submittals?
There's more information. The commission would like to receive.
How long would it take you to submit any additional information that you would like us to see? As we talked about.
Days.
Days. Okay with you?
Certainly.
You want time to respond to that to us?
We probably, I don't know if we will respond. If we do, we'll do it quickly so as to not delay the commission's consideration of the application.
We're by 14th. Friday, the 24th, is that okay for submittal? Gives you days, is that?
Yes.
Go to August, what is it, 6th, maybe the first Friday in August. 7th.
That gives you 2 weeks, that's okay?
That's plenty.
Okay, and we'll deliberate and make a decision.
Yeah, if we are not going to file a response, we'll let the commission know promptly after the 24th.
That'd be nice, yes.
Yes.
So we,
Not sitting there for 2 weeks.
we are hanging around.
Certainly.
I'm pretty busy at the end of July, so. Anything else I've missed? Anything else someone has to comment on?
And so when August, well,
7/24 for the submittal.
Right.
August 7th,
August 7th.
or any response if needed.
Do we need to see if the room's available?
I don't think we're gonna have another hearing. We'll recess this hearing and then we'll wait for your responses and then we'll deliberate, and the next you'll see is a decision. Unless for some reason the commission thinks we need, the supplemental data, but
During recess order or something like that.
exactly. Hold on, let me first.
I think you just said that you would probably issue a recess order before the decision.
Need to.
I think you should.
Okay. After the submittal or prior to receipt?
You should. My advice would be to issue a recess order that outlines what you want.
Okay.
From Ms. LaValle and document those deadlines for submissions.
You say, I'll say so. I'm okay with
I
it.
think that would be a good idea for the record. Writing.
Okay, thank you.
No objections from the applicant. As long as let's stick to those deadlines, we're good to go.
Okay, thank you. Okay, then we're in recess. Thank you all for coming.
Thank you. Have to record it. Black off. For 3 martini lunch.
Oh, you recording still on?
See students.
Yeah.